I'm in trouble.
Pretty careful about that.
Share
I
one.
think it's the one
Is it the share?
at the top of the steps.
Mm-hmm. I don't know why it's not making it full screen. Sorry. Becky, are you able to hear now?
Yes, I can hear now.
Okay, great.
You can get started.
All right. If you want to talk, or you want me to keep working on it? Because I can get it for now. I'm not sure what it is. All right.
That's really good.
All right, well, thanks to Jan and Rob and Steve for inviting me here. Like Rob said, my name's Dan McDonald, and I'm an attorney. I've been practicing about 20, going on 27 years now. Hard to believe. Just a little bit of background about me. I used to practice law at a big firm in Salt Lake City, largest firm in the state, Curtin McConkie. Handled all their trial work, all their litigation stuff. Got burnt out of that. Went out on my own and started my own, what we call a real estate and land use boutique firm, which means all we do is real estate and land use. Like, that's it. Nothing more, nothing less. We don't do divorces. We don't do personal injury, products liability. We don't even do typically general contract litigation. Although we can, we don't. We stick mostly with just real estate and land use. And really where our firm got its start, just a little story about us, was during the recession. During the recession, we were hired by, I was lucky enough to be hired by a joint venture between the FDIC and publicly traded fund called, owned by Colony Capital, who's one of the largest real estate investment firms in the world. And during the recession, they bought up all of the assets of most of the failed banks in Utah. Barnes Bank, Silver State Bank, Arkansas National Bank, if some of you remember those good old days. Anyway, and the FDIC and Colony Capital formed a joint venture that hired us to liquidate hundreds of millions of dollars in loans. And so this is where I kind of got my background, seeing things from the lender's side of things, which will come into play on what I'm talking about today. Anyway, so I just live up the road. We practice statewide, actually regionally. We handle real estate transactions in lots of neighboring states. My law partner does private money lending all throughout the country. And so anyway, this is what we do. It's what we love to do. We geek out on it. And I have to apologize for I'm a little bit underdressed today, but I was inspired by the Pacific Northwest weather that we've been receiving. So I thought I would dress more like Kurt Cobain and Clarence Darrow today. But if any one of you know me, you know that if you can't find me, just go up in the mountains and start looking around, because that's where you'll find me. I love being in the mountains. And when I'm not in the mountains, I like to pretend I'm in the mountains. So thanks for facilitating my my emotional support clothes today. So anyway, want to just make a few things clear. I am not here to give legal advice. I can't give legal advice today. I can't tell you what you should or shouldn't do, what you should or shouldn't tell a client, other than you should always tell a client to hire a lawyer if you don't know. The other thing I want to preface my remarks with is practicing law is an art form, not a science. I came up with this analogy that it's a lot like helping people, guiding people through the legal system is a lot like helping people choose stocks. Like there's no way you can guarantee a particular stock is going to go up or down or do good or do well. All you can do is gather as much data as possible. And it's same with a property or a real estate investment, right? There's no way for you to predict what the market's going to do. All you can do is gather as much data and make the best recommendations possible. And it's the same thing with the law, because if you understand how the law is made, it might help you understand that a little bit better. Law is made in just really two ways. One is the legislature can pass laws, and who knows what they're going to do every year. They do some crazy stuff every year, and they're always tinkering with the law, and they always change it every year. Congress, same thing. Or you have the courts. And the way legal cases work in Utah and in the federal system is you have a lawsuit. The lawsuit has legal issues. Those issues go before a judge or a jury, and they get resolved. And sometimes they get resolved before it goes to a jury, and a judge will decide the case in something called a summary judgment or a motion to dismiss, and the judge will issue a written ruling. If the other side doesn't like that written ruling, they can appeal to what's known as the Court of Appeals. If they don't like what the Court of Appeals decides, they can go to the Supreme Court of the state of Utah. And it's only when a case gets to that level of the Court of Appeals or the Supreme Court that they publish a decision that becomes case law, okay, that becomes valid and binding precedent. So every Tuesday and Thursday, decisions come out from the Court of Appeals and Utah Supreme Court based on disputes that have been resolved, worked their way up through the system, gone to the Court of Appeals or the Supreme Court. And then us as lawyers, we read those decisions when they come out and try to decide, okay, well, this changes the law this way, or this is how the law is going to go in the future. And so that's why I say it's kind of an art and not a science, because sometimes the Supreme Court and the Court of Appeals, they change the law, or they decide they don't like the direction that the law has been going. It's not keeping up with the times, and so they change the law. So I just want to preface that anything I say today, you just have to remember law is more of an art, not a science. All right, so I've got all the disclaimers out of the way. Like Rob said, seller financing is something.
No problem, just having a fun try to.
Seller financing is something I've seen a lot of. I represent a lot of brokerages, and it's been something I've been asked by other brokerages to come in and talk to them about and their agents about, because they're seeing it so often. And it's pretty obvious, right? Why? You got a whole bunch of people locked in to mortgages at 2% or thereabouts. You got current mortgage rates at 7+. So the people who are locked in at 2%, they don't necessarily want to sell, because they're just going to have to find a house that they're going to have to buy at a higher interest rate. But the other people don't necessarily want to buy or get locked in at a higher interest rate. And so you all know, I don't need to tell you what's going on in the market, but that puts a lot of pressure for there to be seller finance deals. And so I'm seeing a lot of those, and I'll just maybe run down the kind of traditional ways of seller financing. And it depends if the house is owned free and clear by the seller or if it's mortgaged. In most cases, it's not owned for free and clear. In most cases, there's a mortgage on the house. And so I'm pretty much just going to assume in what I talk about today, and you should assume that what I'm talking about today is a situation where there's an existing mortgage on the house that needs to be paid off before title can transfer from seller to buyer. Okay. Because if the seller owns it free and clear, it's pretty easy. You can do a promissory note and a trust deed with a down payment. Seller becomes lender. Seller becomes, like Fannie Mae, Freddie Mac, Security National Mortgage, whatever you want to choose as your analogy. And you have a closing and away you go. That's pretty simple. That's pretty easy. There's still risk involved. And if your clients ever want to do that, I would not leave it to the title company to draft a note and trust deed. there's some title companies that are better than others, but they really shouldn't be practicing law any more than you should. I would still refer your clients to a lawyer. It's a really simple thing for me to draft a note and trust deed. I could do it in my sleep. You know, honestly, if it's a really simple deal, it's only going to cost them a few $100 for me to do that. If they don't call and ask me questions, the lawyer's charged by the hour. Okay, so I'm like a taxi cab. If you're talking or if I'm talking, your client's getting billed because yeah, but you get a bigger paycheck when you get a bigger paycheck sometimes when yeah, sometimes. You know, I know how that goes. I do. I have two agents in my family, immediate family, so I know how that goes. So but anyway, that's kind of easy. I would say never do contract for deed. Never. Just don't do it. If you see anyone even talking about it, run. They never work. I've never seen one in 27 years of practicing law that turned out right.
Will you? Contract for teacher in Lena. What's that?
So contract for deed. So you're all familiar with how most financing is done, right? You go, you apply for a loan, you go to closing, you sign a promissory note. I promise to pay back lender this much, and then a trust deed. So the way it works is with the traditional financing is title transfers from seller to buyer. Buyer's on title for like a millisecond at closing. Then buyer signs a trust deed conveying title to the property in trust to a trustee for the benefit of the lender to secure payment of the note until the note is paid in full, at which time the lender will reconvey title, full and clear title back to the buyer. So that's, you know, how a typical financing works is there's a change in title. Contract for deed, there is no transfer of title. There's a contract that says after you make these payments over 5, 10, 15, 20, 25 years, whatever the term of the contract is, after you make these payments, then I as seller will transfer the deed to you as buyer. That's your classic contract for deed. After you have to make all the payments as a buyer before the seller is obligated legally to transfer title to the property. So they're a scam for sellers to exploit vulnerable buyers. Is basically what they are. And in Utah, that means the Hispanic population. I'm litigating one right now. You know, it's very sad to see, but usually contracts for deed are used as a tool to exploit, because what happens is if there's a default, let's say someone misses a payment or they're late on a payment, which always happens. Not always, but very frequently happens. The seller can then say, oh, you breached the contract. I no longer have an obligation to convey title to you. You're out. And then they just get the next buyer in, the next victim in. Again, it depends on what you agree to, right? I mean, these are not black and white. These are terms that are negotiated between buyer and seller. But typically, you know, they just don't work. So when you hear seller finance, you really need to dig in and figure out, well, what kind of seller financing is the seller offering or is the buyer looking for? But don't do contracts for deed. Like if someone asks me, will you draft up a contract for deed? I just say, no, I won't do it. Go find some unethical lawyer who's willing to do that, but I'm not going to do that. I maybe have done one once, and that's because it was already in place and I just tried to make it better than the contract for deed that was in place.
Is it still out? Why is it not banned?
It's perfectly legal to do them, and it's still a thing. I don't know why it's still a thing. That's a good question. I don't know why. Yeah, I mean, I think, yeah.
No, it's your property. You can do whatever you want.
Yeah, it's your property. Yeah.
Credit checks and everything on the people, just like a loan.
Depends on the seller. If the seller, if they want it. There's no requirements. Utah is what we call a laissez-faire contract state, meaning in Utah, if you want to charge 60% interest on a contract, you can do it and the courts will enforce it. There's no usury laws in Utah. There's no laws against exploiting people, really. I mean, there's some consumer protection laws, but I just would never do a contract for deed because it's a long-term contractual relationship. And even big boys have a hard time in long-term contractual relationships, even like Pepsi and their vendors have trouble in long-term contractual relationships. So I just wouldn't do them. I wouldn't do them, but that's what you see out there. Also, you'll see lease options, which are contracts for deeds disguised as, but now lease options are a little bit more legitimate and they're a little bit cleaner from a legal standpoint because it's clear what happens with the lease, right? If it's clear what the legal relationship is, it's clear that there's a landlord and a tenant, a lessor and a lessee. And usually there's just an option to purchase the property at the end of the lease or sometime during the lease. And usually it's a negotiated price up front to exercise that option. And so lease options are a legitimate way of kind of doing seller financing. And the way you can convert those into seller financing is you can say, all right, if you exercise your option to buy, I'll give you X amount of credit towards the purchase price or the option price from your lease payments. All right. So I've seen that. And that's a legitimate way of doing it. But again, that's not a DIY project. That's something that seller and buyer really need to have legal counsel involved. Let's see. The most common thing that you'll see and that I'm seeing is what I would refer to as a wrap or an all-inclusive trust deed and note. All right. And that's because most sellers and most homeowners don't have the luxury of having their home paid off. And so they want to sell, but they've got this problem. They've got a first position trust deed and mortgage with America First Credit Union or whoever the lender is. Okay. And most likely it's a Fannie Mae or Freddie Mac loan. And in that loan, it says there's a due on sale clause. And the due on sale clause says, if you as seller transfer title, then the lender has the right to immediately accelerate the entire balance due on the note, call it due, and you as the borrower have to pay it off. And so there's a due on sale clause in every mortgage I've ever seen, every trust deed I've ever seen. And so what we do with all-inclusive trust deeds is we try to work around that the best that we can. And just to give you maybe, I'm going to start with like a 30,000 foot satellite view of this transaction, and then we can zoom down into like nitty-gritty details a little bit later. But here's how it works. You've got a seller, let's say they have a mortgage to America First, a loan to America First that's in first position, secured by a trust deed in favor of America First. It says, look, if the seller defaults, America First can foreclose, end of story. Buyer comes along, and let's say that note's at 2%. All right, buyer comes along, buyer's out there in the market. Buyer's like, man, I can only get like a 7.8% loan, or I've got kind of crappy credit. I can only get like 8.5%. The seller wants to sell. The seller says, well, look, I can transfer title to you if you give me a note, promissory note, promising to pay me back, and you put me in second position behind America First until I'm paid back, and you promise to keep the America First note current, and you promise to abide by all the terms of my loan with America First. I'll close, I'll transfer title with you, and I'll give you 5% interest or 4.5% interest. And so buyer and seller agree. You come to me and say, hey, before they agree, you come to me and say, I got this seller finance deal and I need help ideally you would have a lawyer or someone like me draft the seller financing addendum. But you would just use the standard Rep C docs, okay? Purchase price is agreed to, closing, settlement deadline, all of that. Do seller disclosure deadlines, all that's going to stay the same. It's going to be like a normal transaction, but you're going to have me help you draft the seller financing addendum. And in that seller financing addendum, I'm going to plug into that all of the terms of this loan between the seller and the buyer, right? And that's how, so that's the first step in doing these seller finance transactions. Then you get under contract, and at that point, I would draft a loan agreement, an all-inclusive note, promissory note, from buyer to the seller, promising to pay the money back. All-inclusive trust deed that's going to, and these are documents to be signed at closing. And so those 3 documents will then not be signed. I give them to you to provide as part of the seller disclosures. And the buyer has 7 days, I think, is kind of the default. And they can look at those terms. If they don't like them, they can walk and cancel. It's like part of buyer's due diligence. If they're okay with them, then they know, okay, at closing, I'm going to be signing these papers. And that's what I'm going to be stuck with. Question here and then there. I use, if I'm going to do a seller finance, if I'm going to do a wrap or an all-inclusive trust deed, I do a loan agreement, which I prepare, an all-inclusive note, an all-inclusive trust deed.
Yeah, I was just gonna say, you called it a wrap earlier. Is that like a wrap with a W, or is that a?
WRAP. We call it a wrap because it wraps around the existing mortgage.
Okay.
All-inclusive, no, yeah, no, good question. And we call it all-inclusive because it includes the obligations of the new buyer, include the obligations that the seller has to its lender, right? So it includes the obligation seller has to America First Credit Union. Plus, so the buyer, at the end of the day, the buyer is going to have to make sure that that first position, and the seller is going to want to make sure that the buyer keeps that first position loan in favor of America First in good standing, and keep the loan from seller to buyer in good standing. And then what we do to make sure that the payments flow back to America First after closing, we use an escrow company. Escrow Specialist is really the only company I would trust to do this. You set up escrow, and after closing, buyer pays the money, whatever you agree to between buyer and seller, pays the monthly payment to Escrow Specialist. Escrow Specialist then divvies, out America First's portion. If there's excess, it divvies out what the seller's portion is. And with the difference between a 2% and a, say, 5% interest rate, there could be money to be made for a seller. There can be monthly cash flow from this for a seller. And that's the basic kind of outline of the transaction. And that's how we do it. And then typically, though, this is not a long-term solution. I have seen agents draft seller financing addendum where they had their seller promise to carry for 30 years. No, don't do that. You only want this to be, say, like 3 to 5 year term at most, so that in 3 to 5 years, that buyer who the seller's financing has to go out and get traditional financing and pay off the loan.
Sell it.
Or sell it, or sell it, yep, or sell it. So you want typically what I'll do is I'll amortize the payments over 30 years so that the buyer can afford the monthly payments, but there's a balloon at the end of the when the seller financing note and trust deed is due. And that's typically how I structure those, just from a kind of a satellite view. Let's see here if I forgot anything on my notes.
I have a question.
I got a question.
Yes, so I'm just about to do this, and I am doing it through a promissory note. I do own it outright. So you're saying when I write it up with a attorney, I should do it with an escrow specialist for less than 5 years?
Well, okay, yeah, are you the owner?
I am.
You own it outright?
I do.
You don't have a first position lien or anything? It's just free and
No.
clear?
Free and clear.
No, yeah, you don't need escrow specialists in that case. You can just do a note and trust deed.
Okay, that's all I need to know. And then how do I do my payments? How do I get my payments?
Well, I'd be happy to talk to you about that after the class, but I can't give you legal advice over the
Okay.
Zoom. I'm sorry, but
So I was just wondering, do promissory notes done through a bank or are they done through a title company? How does that done?
Yeah.
Just a legal, it's just a legal note, right?
well, my advice is that you hire a lawyer, okay? So
Okay.
no, this is not a DIY project, especially with your own equity. You own your home free and clear. This is like your future. So
Okay,
don't be
Right.
penny wise and pound foolish. Don't step over.
I was just trying to apply it to what you were telling us. So go
Yeah, no,
go ahead with your notes.
no. Okay, yeah, good question. And it just so you know, some people in your situation where they're just doing straight seller financing, not a wrap, not an all-inclusive trust deed, they will still use escrow specialists. Because
I've always advised.
Yeah.
Use escrow specialists, whether it's a no deed of trust or all inclusive. The main reason is because now that gives some reassurance from the seller side and the buyer side. The buyer can be confident that the money is actually going where it's supposed to, there's record of it.
right.
And so it's just, but whether they agree to do it, that's up to the buyer and seller.
Right. Right. All right, good question. Okay, so now I'm gonna drill down into like some of the more nitty-gritty mechanics. Yes. Yes. Because most people are not capable of properly amortizing a loan. Like, what would you do if they made an extra payment? You'd be like, oh, if it was me, I mean, I'm terrible with numbers. I get an extra payment. I'd just freak out. I wouldn't know what to do with it. Right. Yeah, and they'll handle, yeah. So I would set up, and now they'll handle payment of the county property taxes. They'll handle payment of insurance. So I would recommend you always use escrow.
First side of the month.
Yeah, it's amazing how cheap they do this for. All right, so let's get back to wraps and all-inclusive trust deeds, because that is what you're going to be seeing out there in the market. The big issue, like I said earlier, is technically speaking, if you do a wrap or an all-inclusive trust deed, it will be a violation of the underlying trust deed to America First. In our hypothetical, America First, if you were to pull its trust deed with the seller, it's going to say, if you transfer title while we still have our trust deed recorded at the county and while our loan still remains unpaid and outstanding, you're in breach of this trust deed. We can accelerate the entire balance due under this mortgage and foreclose if we want to. Okay. So that's what the due on sale clause says. And technically, if you do a wrap or an all-inclusive trust deed, you are transferring title from seller to the new buyer. And you are violating that trust deed. And you are triggering that right for America First to go ahead and foreclose, accelerate, and possibly foreclose. Okay. So that's a risk that you shouldn't explain in great detail to your buyer. That's something a lawyer really needs to explain to them, which is another reason you should refer anyone who's thinking about doing this to a lawyer, so that I can go over all these risks with a seller or a buyer who's thinking about doing this transaction, because there are risks. Now, in one of the classes I taught on this, somebody says, well, isn't that illegal? And my answer is no, it's a breach of contract. There's a difference between something that's violation of the criminal laws and something that's a violation of the civil laws. You could have civil liability for doing this, but you're not going to have criminal liability for doing this. And there's a difference. So how do we deal with that? As lawyers, what we try to do is we try to manage that risk the best that we can. And so in that loan agreement, well, first of all, remember when I said law is kind of an art, not a science? Couple things. In 27 years of doing this, I have never seen a lender personally call a loan due. And I have a few theories for that. One is I've had the good fortune to live through times of historically low interest rates. I've also know lenders well enough to know that they're greedy, and as long as they're getting paid, they don't typically care a whole lot, right? Now, Rob told me just this week that he went to a seminar at the UAR convention where a lawyer said that he's seen 3 lenders accelerate and call these loans due on the due on sell clause recently. And I personally haven't seen it. I have no reason to doubt that that's happening. There's an obvious reason why a lender would want to do that, right? If you're a lender and you're stuck at a 2%, earning 2% interest on a loan for 30 years, when you could just say, look, I'm going to recapitalize this account and I'm going to take that money and I'm going to go out and lend it at 7%. A lender has every incentive, okay, to do that. So it's probably riskier now with the higher interest rates. I still haven't seen it, but you know, it could theoretically happen. And the scary thing about that is with the interest rates the way that they are, let's say interest rates weren't so high, I could always make the argument, well, no harm, no foul, okay? Let's say a lender tried to accelerate. I could say, well, is that breach really material? Because the lender's been getting their payments every month. Like, how could the lender say they've been damaged by that breach, right? It's a technical breach, yeah, but how's the lender been damaged? They haven't lost a penny. I could always say that up until you have this huge difference between what the lender's interest rate may be locked in at and current interest rates. And there's case law that I'm aware of that says, look, a lender, let me back up. And typically the Utah courts have not liked due on sale clauses. Utah courts have done everything they can to not enforce them because they are what we call a restraint on alienation. Utah courts do not favor restraints on the free trade of stuff. And the one exception to that the Utah courts have said we might consider, but they've never ruled on it yet, is if there's a huge difference in the interest rate between what a lender's locked in at and what they could get on the market currently. What's that? No. They could just say that. And that's the issue, is we don't know if a lender can successfully make that argument in Utah. We think they might be able to, but the law is an art, not a science. We don't know what the current members of the Utah Supreme Court think or how they would rule on that. Question. Good. That's true, although just being devil's advocate, and that's a great point, and they would make that argument, and they do make that argument, but the response to that is, well, you're oversecured. Like if they're oversecured, no harm, no foul. If there's not been a monetary default in the payments, no harm, no foul. Doesn't really matter. And third, theoretically, the buyer in a all-inclusive is not assuming the loan vis-a-vis the buyer and the lender. They're assuming the loan vis-a-vis the buyer and the seller / primary borrower, if that makes sense. Yeah, Rob, you had a comment, question.
Yeah, the key thing that I want to emphasize in what you're talking about right now is in the event, if maybe even when these situations become a legal matter, the fact that it's being handled by an attorney automatically now the attorney is assuming the liability versus we as the agent or the company if something were to go wrong, because the client would be hiring the attorney to represent them, versus if we take this upon ourselves to do it, we're now injecting ourselves as being involved in the potential risk of any matter that occurs.
Absolutely. Do not be a realtor at law. Us lawyers have a term for realtors who try to practice law, and we call them realtors at law. Don't be a realtor at law, because if you hold yourself out as having knowledge of how to do these transactions, the courts will hold you to the standard of a lawyer. And if you don't live up to that standard, you will have liability for malpractice. So,
And you would.
absolutely, she should not be drafting a note in a trustee. Those are legal documents. There are very important terms to include. Unless she can, unless someone is capable, I wouldn't even let a title company do it, because unless someone's capable of understanding what presentment, demand, notice of waiver, the rule against perpetuities, all of these things are, they shouldn't do it. They shouldn't do it.
I think that situation still needs to go.
Oh, yes. Yeah. She needs to go through a title company, and she needs to be insured in first position. You need to pretend like you're America First. When you're in any of these scenarios, whether you own your home free and clear, if you're going to do any kind of seller financing, you've got to go through a title company. You've got to get a lender's policy of title insurance, ensuring your lien position. Because if you don't, and there's a glitch in title, you lose your security, you lose your retirement. It's a bad deal.
One last thing, Dan.
Yeah.
I think confusion comes from when we're talking about doing this seller finance addendum,
Mhm.
is the part in the addendum, in section 1.1, it talks about creation of documents.
Credit documents.
The creation of the documents we were
Mhm.
talking about, where it's gonna be created by seller or buyer, basically, who's gonna be responsible for that?
Yes.
That's where if you were to check seller, where the seller would be obligated to go to an attorney
Yeah.
to have the note, those documents created, or the buyer is gonna go and have them
Right.
created, not to take it upon the seller. The other portion of the seller finance addendum, that's where I think agents are thinking, oh, well, I do all that, I create all
No.
of that. And the addendum it separates the documents you're talking about
Right.
already in.
And I'm going to go so far as to say, you as an agent, I personally do not believe agents should be filling out seller financing addenda in an all-inclusive situation. The reason why is because there's certain loan terms that you've got to put in there. And if that's where I saw an agent obligate a seller to carry a loan for 30 years, because they didn't know how to write up a 30-year amortization with a 5-year balloon. They didn't know how to do it. So this seller got stuck with it. Fortunately, we were able to renegotiate, but you should involve the lawyer early, let the lawyer draft the seller financing addendum. And if you look in the seller financing addendum, you'll see a term called credit documents, and it has capital letters. If you look, it has capital letters, and judges and lawyers, we look for terms that have capital letters, credit terms.
Yeah, it doesn't, it's the creation of documents is the way it's termed here.
Okay,
Oh, sorry, no, under section 1, it does say credit document.
Okay. All right, I thought I was having a brain aneurysm there for a second. Okay, so those credit documents, that's the loan agreement, the all-inclusive promissory note, the all-inclusive trustee that I draft. All right, and so those credit documents, if you follow the term credit documents throughout the seller financing addendum, that explains how these documents are drafted, when they're disclosed, and so forth. And so those credit documents that the seller financing addendum talks about are what I draft and what you should not draft. A title company should not draft them. But there's a lawyer at the title company. Well, here's the problem with that. Who's that lawyer's client? Who's that lawyer looking out for? I don't know. Your guess is as good as mine, right? Who does he represent? If he doesn't have a client or she have a client, they're probably not looking out for anyone's interest. They're probably just pulling some forms from some other transaction that they did and just plugging in the names. Instead of saying, okay, how can I protect my client given my client's unique situation and circumstances? should, yeah, most of them don't. No,
Well, you can't split the title if you don't have two insurances going out.
no, but she's talking about lawyers. I think
see.
their own representation as lawyer. Ideally, a buyer should, so that the buyer knows, but most buyers, like even, you know, when you get a traditional loan with America First or Security National, you don't get a lawyer to review the docs. Because why? Because the lender gets to dictate the terms. The lender's like, hey, these are my terms, take it or leave it. Right? So that's, most buyers don't get a lawyer to understand. Now, if you have a buyer that's going to do a seller financing deal, I would advise you to have that buyer look at the documents, because there could be lots of gotchas and trapdoors and things that are unfair. So, so how do I deal with this due on sell clause? Well, I don't know. Well, I'll get to it probably. How I deal with this due on sell clause. What happens then? Like, what's the worst case scenario? Let's say you do a seller financing deal. America First finds out about it. They're like, oh, goody, we can call this loan due. We can accelerate and foreclose and get out of our 2% for the next 25 years. So how can we hedge around that and protect the seller? Because the seller's the one that's going to kind of get screwed in that situation, right? Because all of a sudden the seller's like, oh my gosh, I got to pay off America First. I don't have the money. They're going to foreclose. So what I do, and again, law is an art form, not a science, because I don't know if this will work. Okay. And just being honest, and the reason I don't know if this will work is because it's untested in the Utah court system, and it probably won't percolate through the court system for another 10, 15, 20 years, maybe never. But what we do as lawyers is we do our best to create leverage for the seller. So what we do is, in that loan agreement that I draft, I have specific clauses that deal with what if there is a due on sell and acceleration by the primary lender. And part of what I do is I say, look, if there is an acceleration and a due on sale by the lender, that's a risk that you're aware of, buyer, and that you're assuming. And at closing, I'm going to have you sign a warranty deed in lieu of foreclosure. Because if my lender accelerates, that's a default, and I have the right to foreclose. But what I want is I want title immediately back in my name. And so what I do is I have at closing, I have the buyer sign a warranty deed in lieu of foreclosure, but I do not have it recorded. I just have it delivered back to the seller. And the seller can only record that if there is one of these events of acceleration by the primary lender. So if there is an acceleration, the seller has the option of getting immediately back on title. Then the seller can go out in the market and refinance. And I won't get into all the legal terms and legalities, but whether that's legal or not, whether the court would enforce that, because technically that buyer who's giving you the warranty deed in lieu of foreclosure, they have statutory rights for default, reinstatement, foreclosure rights, and they're waiving those. But I basically have the buyer waive those rights in the loan agreement that they sign. Whether a court's going to uphold the waiver of a statutory right, your guess is as good as mine.
And Bob, I sent those warranty deeds to escrow specialists and have them for escrow with instructions.
And have they held them for you?
just for the
Yeah.
Buyers are like, we don't want to do that.
Yeah.
Deed
Yeah.
if he wants to.
Yeah.
So,
Yeah, that's good to know. I usually hold them myself or have my client hold them. So I didn't know escrow specialist who's willing to hold them. That's good.
So I think section 6 talk about the I believe it's spelled out there, if it is called, it's basically coming upon the buyer to refinance whatever it is. Would the seller potentially have recourse? Could they go out to the buyer? I would say the buyer couldn't refinance, or when rates were too high, they couldn't qualify to refinance whatever it is. America First comes to the seller and said, hey, we're calling this, we're foreclosing, whatever. Could that seller potentially go out to the buyer and say, you agreed that if this had happened, you were gonna make this whole when you can, I'm gonna ask you. That's what that section is for, that, and
Section 6 of the seller financing standard.
it's 5, sorry.
It's fine. Part of it said.
Mhm.
The remaining balance owed to the, due on sellers underlying, underlying mortgage.
Right,
On sale payment.
right.
Such, you want me to?
No, but that's what I'm saying is in the loan agreement, what I do is I take section 5 and I say, look, if you haven't paid off that, if you haven't paid the first position lender off within, and the bad thing about section 5 is I don't think it has a set amount of days.
It's not very,
So I take that and I kind of fix section 5 and say, look, you have like this many days to pay off that first position lender. If you don't, you're in default. And here's the remedy. So that's about the best that we can
the
do.
document called right up instead of that,
Well, I write up a loan agreement
but the.
and as an exhibit to, as part of the loan agreement, I do a warranty deed in lieu of foreclosure.
That's great.
Or we call it a DIL, a DIL, a deed in lieu of foreclosure. A DIL.
I've had a lot of savvy investors just lately. And we've been through this whole process of how I want it to go down for my seller. And boy, they're tricky. They will not give a deed in lieu of foreclosure. And I'm like, well, if you're gonna make a payment. And that deed is sitting in as a specialist, why do you have a problem?
Right.
No, they will not agree to a deed in lieu of
Yeah.
foreclosure. And so.
You don't want to do a deal with someone like that, right? Right. That's a great filter.
Yeah.
At the best, it's
I
a
think
great
people
filter.
figure it out. Yeah.
Well, they know because it's out there in the market, right? That's,
Just for the people online. it's-
oh, I'm sorry.
Hear what is being asked.
Okay, so I think the last question was, does section 5 give a seller who does an all-inclusive trust deed transaction the right to hold the buyer in default and make the buyer pay off that first position loan to say America First Credit Union? And the short answer is yes. But I don't think section 5 is quite good enough. So I use a loan agreement that kind of augments those rights for the seller and actually gives the seller more leverage by holding that deed in lieu of foreclosure that they can record. So that's about the best that we can do to protect the seller. And whether that's going to work or not, I don't know. I mean, because statutory rights are really important. Just so you know, the normal process for foreclosure, and this goes for both the seller vis-a-vis America First, and then the buyer vis-a-vis the seller, right? Because both are borrowers. If America First forecloses, both have statutory rights if there's a foreclosure. And under the foreclosure statute, just so you know, and as a reminder, the process is before a lender can come and take property through foreclosure or sell it through foreclosure, they have to first record a notice of default at the county recorder's office. Then they have to sit and do nothing for 3 months because every borrower has a 3-month right to reinstate the loan. If the borrower does not exercise the right to reinstate the loan during that 3-month period, then the lender can proceed to sell. They have to publish notice once each week for 3 consecutive weeks, the date and time of the sale. All right. And then they have a sell and the property is sold to the highest bidder. Sometimes the highest bidder is the lender, if nobody else shows up at the sale, who credit bids the amount of the loan. And then the trustee, under the trust deed, will do a trustee's deed and transfer title to the lender or whoever shows up at the trustee's sale to buy the property. That's the normal timeline, right? And so even if there is an acceleration and a triggering of the due on sale clause, your seller is still going to have some time to figure this out and either get refinancing or work something out with the lender, so on and so forth. So anyway, just so you know, that's I've been signed out because you are currently signed in on another device. Okay.
You are totally fine. You're still signed in.
Okay, great. All right. So yeah, I've explained the foreclosure. All right, at the end of the day, this is just the best thing you can do. If someone says, I'm thinking about offering my property and offering seller financing, that's fine, it's perfectly legal. But the thing you've just got to do is you've just got to say, look, you have to get a lawyer. I can't walk you through this. I'm an expert on marketing, the market. I can help you price the home right. I can work, and usually, so you should refer them to a lawyer. Then when I get involved, I usually include you as like a valuable member of the team, right? I mean, you're usually going to be my liaison as far as communicating between the seller and me. And we're going to be coordinating to make sure we time the disclosures right, to make sure that we get the documents to closing. You're going to be working with me to tell me who the title company is. Right before closing, I'm going to be sending lender instructions, escrow instructions. You know how at closing, title's always waiting for the documents, lender docs. Well, they'll be waiting for those lender docs for me, right? And I'll be telling the title company, you can only record once you provide me with this, and this, and I'm going to make sure that they're in an insured position and so on and so forth. So the best advice you can give to a buyer, seller, whoever you have as a client that's either thinking of offering a property for seller financing or buying under seller financing is get a lawyer, all right? Because there's just too many things that could go wrong. And I've seen a lot of crappy legal documents out there drafted, and it's amazing that people survive those. But so again, don't be a realtor at law. You don't want the liability. And I think that's why Presidio has kind of decided, look, if you're going to get involved in these transactions, you just have to have a lawyer involved. And that's really good advice. It's going to protect you. It's going to protect your clients. All right. At the end of the day, remember, I'm not giving legal advice here. I'm not advising to do these, not to do these. I'm just explaining what's out there. But if you have questions or whatever.
Hey, Dan, there's a question
yes.
in the chat.
Oh, okay. Question in the chat. Let's see if I
Can you see it, or do you need me to read it?
How about you read it? It's not pulling up from, oh, there it is. This is not a CE core class.
No, it says, I have a question about how to handle the homeowner's insurance on the property. Having the buyer's name alone on insurance could trigger the lender to look at the note.
Very good question. Fire and hazard insurance, how to handle that. Funny you should ask. The last one of these I did, my seller was an insurance professional. And so she was like all over this, type A. And you've got to find out, and it's my job really to do this. And it's not necessarily something that you as a realtor need to worry about. But part of what I do is I try to figure out who's going to be the end user of this house. Are there going to be renters? Is it an investment property? Is the buyer going to be living there? If the buyer is going to be living there, I just have an insurance requirement. And that policy has to, you still have to have America First on the insurance policy. But if you don't, that's a default under the first position trust deed. But then you're going to add you as a lender, as a loss payee, or if possible, an additional insured. And I can't remember the insurance. They're changing the insurance terms all the time, but you're gonna be listed right there alongside America First, and you're gonna insist and make it part of your deal that the buyer has to keep the property insured. An escrow specialist is going to collect money and make sure that those premiums get paid. That's part of their job.
I think where this is coming up is because the change in
Yes,
insurance,
it will notify them.
it notifies the lender. So where this comes up is we make the seller still remain on
Right.
insurance, then we're not gonna notify the lender of any change. And that's the direction.
Yep. No, there's that. There's the if you want to try to You could have two policies, all right, if you are really, really super worried about the lender being changed, or, you know, America First all of a sudden getting a notice from the insurance company saying, well, why is this person now insured as a lender? If you want to pay the extra, I suppose theoretically you could get have it double insured, but there's just really no way to, covering it up, and you don't necessarily want to cover it up. I'm not saying that. That's not what I said. I said they might. I'm not saying they will.
Yeah.
Oh, yeah. Yeah. If you don't keep the property properly insured, that's a trigger for a default. Yeah.
Oh my gosh, wow, that was a big deal. I told my seller, do not cancel your homeowner's insurance.
No.
Do not do it. She moved to another home, called her agent, and like, oh, are you still living in this home? Yes. Yeah. And
So
she's like, no, and she's like, oh, well, you don't need that policy anymore. So I'm like, so she calls me, I'm like, Katie, why did you, that was like the golden rule, do not cancel your policy.
You did what I said to not do.
Yeah.
Yeah.
And so
Do not cancel insurance. Yeah.
Title. They would not give her insurance.
Really?
Yeah.
Did they give her
would
the
not
loan
insure.
documents?
Yeah, so, she just got online and got Geico.
Because she should be able to get insured as a loss payee. I've never had, what's the term? I'm just having a brain
That's the
cramp right
biggest
now.
trigger.
But yeah, you got to keep the property insured.
And then my seller's policy. But if the home burns down.
Good, interesting fight between insurance
Yes,
companies at that
Yeah.
point. It could be.
Hey, Dan, there's a few more questions. I think 3 more. One
Okay, great.
says, how do you protect the buyer if the loan is called due?
Okay, how do I protect buyer if the loan's called due? I kind of talked about that. That's through the warranty deed in lieu of foreclosure process, and that's what I was referring to earlier. I got another question here. Can you also explain how a buyer's down payment would be handled? Oh, I'm glad someone asked that. Would you do a non-refundable down? Yes. Yes. On down payments, I think if you're trying to protect your seller, you want as big a down payment as you possibly can. And the down payment is just, it's non-refundable. It's just part of the purchase price. So, but what you want to negotiate for in terms, if you're representing a seller, is a very large down payment. And then a very short term for financing. I would not carry one of these for more than 3 years, preferably 5 at the very max. Any other questions?
Yeah, there's a few more on there.
How can a mobile home without land? Oh, good night. A mobile.
Wow, it's not real property.
It's mobile home is not real property. So if it's without land, I just wouldn't do those transactions. But it's like a car. I mean, you theoretically could do it, but you're not gonna have foreclosure rights. You're gonna have a security agreement with a UCC1. It's a default on the loan. You're gonna have to set up repo rights. So good question, but oof. Yeah, run. Don't do that. Commission's not big enough for the commission's not big enough for the brain damage that deal's gonna cause you, man. Woo. Okay, other questions on chat?
No, they're all fine. Thank you.
Okay, Kate has one more.
So when a buyer, let's say the note's called due, and the buyer has paid 4 years of payment, plus they gave $100,000 down. All of a sudden, the title's in their name. How do we remedy for the buyer's loss? Really, they went into it knowing that was a risk. Is there a renegotiator? They just lose out? They're just done?
You're talking about if the primary lender accelerates forecloses, at that stage,
Skip it.
right, the buyer's lost his down payment, and the buyer's lost all the payments, and this is why I don't know if it's going to be enforceable, because the way I draft the clause, it says the buyer gives up all of that. We don't call it a forfeiture, because if it's a forfeiture or a penalty, it's illegal and unenforceable. So we say, look, if that's the situation, buyer realizes that these are the liquidated damages to the seller. Right, yes,
So they just kind of
they forfeit all of it.
Put the clause for them that they, or they're able.
But the problem is your seller's not,
So.
the seller's,
For money.
their seller's not gonna be able to come up with the money to,
or rebuy it from them.
Right.
right, I mean, the reality of what's gonna happen, it's a really harsh clause, but, the reality of what's gonna happen is the enforceability of that clause is gonna, if it's a, yeah, if they pay attention to it, but the reality is what's gonna happen is there's going to be a renegotiation at that point in time, and there's gonna be a retrade. If it's a situation where, like, the worst case scenario for the buyer is right before the balloon payment was due, right before they were gonna refinance, there was an acceleration and they lose all of this money. That's the worst case scenario, and there's no easy way to allocate that upfront, because we don't know if that's gonna happen.
And you never had it.
No,
Oh.
I've had it happen in a contract. So
Yeah.
I've had it happen in a contract for deed. I've had it happen in a contract for deed, but not in a, yeah. And typically what's gonna happen is the buyer's gonna say, hey, I have statutory default rights. I have a 3-month right to reinstate. And so what's gonna happen is and they're probably right. But if there's a default, the seller absolutely has a right to foreclose. And the buyer's probably gonna say, look, I have a statutory right to reinstate. Let me work on financing to pay you out. And I'm gonna say, okay, 3 months, you have 3 months, and I'm gonna start the foreclosure process to clean it up. If that makes sense. But that's the risk in the beginning. The risk is their down payment, that's correct. And all the payments they've made. Yeah.
So, Rob, you do when you talk to the buyer and seller, this is happening in front of mine right now. Let's say the loan is 500,000.
Can you guys hear online? This question?
Not
Yeah.
super good.
So I would.
Okay.
So if the loan is, if the seller owes the mortgage company $500,000. And we get $100,000 down payment, okay? So the buyer now only owes $400,000. Right? To the seller. The
Okay.
buyer only owes $400,000 now to the
Okay,
seller.
so purchase price is 500,000, buyer puts 100,000 down, 400,000 is carried by the seller on the note. Okay,
That $100,000 goes to a new car, a new down payment, whatever. The 5-year balloon comes due. The buyer now only owes $350
okay,
to the seller.
5-year balloons due, buyer owes 350 to seller.
The seller did that $1,000. Now we have a deficit, a shortage on that underlying mortgage.
So, okay, the part you left out was what is the
So-
amount of the underlying mortgage? Cause
But, so
so the,
what I wanna talk about is how important it is for agents to educate their escrow officers. And to say, hey, you gotta bring that mortgage down, you gotta do a principal reduction. With that 100,000, because in 3 years, the seller could be divorced, bankrupt. How are we gonna make that underlying mortgage complete? And it is a problem.
yeah, So that's where a buyer needs legal counsel, because that's something that
Yes.
a lawyer for the buyer would look out for. Right, yeah, you gotta figure that out before closing, and there's, yeah, and usually it's not a problem, because people who are doing seller financing have enough equity that's obvious from the face of the, from the loan documents. I mean, you can ballpark the math, right? Someone's got, wow.
Yeah, with $100,000. I said, Brian, you gotta put that, otherwise when they pay you off, you gotta.
Right, and so that's where a buyer really needs their own legal counsel to say, look, as a condition of closing, this down payment has to go towards a buy down, pay down of the principal loan or principal reduction. You can through escrow specialists, yeah, through the title company. The title company would take the down payment at closing and disperse it to the first position lender. If the buyer really wanted to be protected and make sure that the down payment went to a principal reduction payment. You'd want to put that in the original negotiations, yeah, and in the loan agreement, because the loan agreement it sets out the lender's obligations too, so.
And there's no.
But that's where we would deal with that issue, is in the loan agreement. And that's why we have a loan agreement, not just a note and trustee. You get the lawyer to do the addendum. And if that's an issue that's in the transaction, the lawyer is probably going to put something in the seller financing addendum saying down payment must go to AFCU at closing. Yeah.
So basically, if the seller is buying it for 500,000, the note to the lender needs to be brought down to 500,000.
Yeah, or if you're looking at title, I mean, if you're trying to screen these for your buyers, if you see you should pull title, you should look at the trust deed, you should look at the face amount of the trust deed, you should ballpark the math. And if it's just too close between your purchase price and what they owe, don't do it. Because then it's potentially going to be a problem. So that's how I would screen these, is properties that are suitable and not suitable for seller finance. All right, Bob's going to kick me out of here.
We sincerely appreciate you doing this.
Okay.
A lot of questions. I think the key message here is use an attorney.
Yeah, key message. This is not don't be a realtor at law. Please don't be. I don't want to. No, they say they know it, but they don't know.
Yeah.
Phone number 801-372 0055. Oh, really?
Yeah. Tim, the phone, 801-372
0055. Pleasant Grove. Yeah. Yep, I am in no need of extra overhead.